Division, Supreme Court, First Department. PDE, all persons having business with the Appellate Division. So I'm here, give your attendance, and you shall be heard. Please be seated. Good afternoon. Welcome to the Appellate Division, First Department. We have some 5.5 hours of argument time requested, which would keep us here till 7:30. And I don't think any of you wish to stay quite that long. So please adjust your request accordingly and only ask for the amount of time you really need. Did anybody hear what I said? Because they just turned my mic on. Generally speaking, I can be heard without a microphone, but I will use it. Okay, I'm going to call the calendar now. People versus Lugo. I can't see back there, so you'll have to... Nobody submitted. Connors versus the City of New York. Submitted. Alozio versus New York Presbyterian. Where? You know, we have 110,000 lawyers admitted in this department alone, and this room is filled with brilliant lawyers. It always amazes me that we have to go to Pennsylvania, or Florida, or California to find someone as brilliant, but I will accept your representation that he's up to it, so he can argue. But how much time do you want? I'd like 8 minutes for my primary argument, Your Honor, and 2 for rebuttal. Is there a respondent?
Good afternoon, Your Honor. Plaintiff respondent requests 5 minutes, please.
Good afternoon. Defendant respondent requests 5 minutes.
Okay. Ferguson versus Durst Pyramid.
Good afternoon, Your Honor. For Appellate, I request 5 minutes.
Thank you. People versus Bulina. I didn't hear that. Thank you. 463 Saddle versus Union Mutual. Appellant? The way you're looking around, it seems that you're the respondents. You want to argue against yourselves? Is that the idea? Or do you wish to submit? Okay, submission. Thank you. Rosa versus McAlpine Contracting. Is there yes. Are you the appellant or the respondent? Appellant? Appellant? You all wish to submit or argue against your position? Very good, thank you. People versus Torres. Thank you. Highland Crusader versus Celtic Farmer.
Jonah Jaffe from Reed Collins inside for Appellant. Introducing my colleague, Greg Bono from the Bar of the State of Texas and requesting that he be permitted to argue.
Again, I'm befuddled that we have, like I said, 110,000 lawyers here, and we have to go all the way to Texas, but I will allow you today. How much time, you're the appellant, right?
Correct.
How much time are you requesting?
We're requesting 5 and 1.
Respondent, we would request 6.
Thank you. 470 4th Avenue versus Adam America.
Ellen, didn't see this. Request 4 and 2, Your Honor.
You're from New York, right?
Yes. Let's have a look.
Appellant, 474,000 investors, and Adam America request 5 minutes.
Thank you. Well, 10's a little, how about 7, okay? Thank you. Cepeda versus the City of New York. Thank you. Schachter versus Schachter.
Appellant here,
How much time do you request?
the full amount of time, and I'm going to need to split it by leftover time for reply.
Well, how much time do you want for your main argument?
Depending on how long it goes, I timed it about 8 to 10 minutes, and then the reply for the rest, whatever I have left over for the rest.
Okay, and where's the respondent's attorney?
Thank you.
I didn't hear you. Yeah, but how much time? 8 minutes. 8. All right, this case is going to be called first. Okay? There's one more? Oh. Okay. Triborough Bridge versus the Triborough Bridge. How's that? Triborough versus Triborough? Nobody over there? Okay, that's submitted. Well, it is submitted anyway. Belofsky versus the city is submitted. Carrasquillo versus Wilford Realty is submitted. First case to be called is Schachter versus Schachter. Now, just so that you all know, I don't know if they were told before, but Judge Oing is participating, and he is on the screen, and he has the ability to ask questions and to hear and see everything. So,
Can you hear me, Justice Mazzarelli?
yes, I can hear you. All right, Ms.
Thank you.
You're the appellant, Ms. Schachter. You go first.
Okay. Thank you, Your Honors. Everything is upon information and belief. Imagine if your ex-husband's attorney, Judy White, hired Judge Drager, the judge you were before, for 12 years, and neither White nor Judge Drager advised you for 7 months. Judge Drager never advised me. White waited 3 months after I informed her I knew to send me undated screening practices. Imagine if Judge Drager, who White hired, imagine if Judge Drager appointed the receiver, Yariv Ben-Ari, who conveniently then sold your Bridgehampton home to ex-husband 4 years after the receiver listed it and billed $153,000 plus to sell the home to ex-husband. This was after receiver billed $80,000 for a simple house closing for our brownstone that had no mortgage. Imagine if your ex-husband torched. Yes, torched is correct, since he used a blowtorch and burnt down the garage and pool house while welding a car near Solvent, a pool, and a garage heater in a wooden garage. Now imagine if the ex-husband failed to rebuild the garage pool house, receiver nor Judge Drager, who White hired, questioned the fire or demanded to rebuild. The Jobs Lane Bridgehampton house, 6 houses from the ocean, didn't sell during the pandemic Hamptons boom, since the house, according to our initial broker, looked in disrepair. But the person who did buy it was ex-husband, 6 years post-divorce and 4 years post-receiver, the same person who failed to clean the property and rebuild when he caused the fire. I don't have to imagine any of this, since this happened to me. The scenario is right out of Casablanca, where Lewis in Rick's Cafe says, "I'm shocked to find that gambling is going on here," as he collects his gambling winnings. But of course, they weren't shocked. They were just hoping you wouldn't notice, and the information wouldn't come out. Receiver Judy White, Judge Drager, and Ira Schachter colluded with White's firm to line each other's pockets like a cabal and created irrational world. White claimed she didn't represent my ex-husband, Ira Schachter, but wow, here she is today. White, Ira, Judge Drager, and receiver pick and choose details and curate the truth through omissions, half-truths, lies, covered up with another lie to distract you from common sense, and then blame me. It's unfathomable no one would purchase a home 6 houses from the ocean during the pandemic boom when people were in bidding wars to buy homes since there was no inventory. The cabal blamed me. except, as Justice Acosta noted previously, I couldn't speak to the broker and I had no access to the house. In Irrational World, Judge Drager had me, a non-moneyed spouse, pay half the mortgage and then barred me from the house. So Ira, a Cadwalader partner, had me, a non-moneyed spouse, subsidizing his Hamptons holiday. Why was I barred? I hired a locksmith to open the unauthorized change locks on the garage to see Ira's $300,000 car building equipment after Ira didn't pay my support and told the court he would declare bankruptcy if forced to pay his daughter's Ivy League tuition. After he bought a Porsche, the infamous $215,000 engagement ring. And of course, he didn't declare bankruptcy. Spoiler alert. The IRS filed a $193,000 lien against Ira. I had a no-change federal and state audit. In Irrational World, Judge Drager failed to ask for proof of payment with a wire transfer or a bank check. Thankfully, the IRS does. The collaboration is so bad, the Grievance Committee notified me in February 2022 that Judy White was a Grievance Committee member since 2019, despite my filing a complaint against Judge Drager, her of counsel, in July 2020. While the committee claimed White no longer represents Ira, the committee later claimed there was a computer error, despite my sending irrefutable legal documents with her name on them to the committee.
Ms.
White
Schechter,
also joined.
the white light has gone on. That means you have 2 minutes left.
White also joined the Women's Bar Association board, where Judge Drager was a board member while on the bench, and both failed to disclose they were on the same board. It is unfathomable that White claims she had the first conversation on January 1 and Judge Drager started on February 1. It's unfathomable a judge who couldn't finalize a divorce in 12 years negotiate a contract in 1 month. No one provided notice, which Rule 1.12 requires from the first conversation. White claims she didn't represent Ira, but here she is. They had conversations starting in June 2020, but White didn't fail to send screening notice until September 11, 2020, and it was undated. She didn't notify me. She claimed she put in, it was an article in the New York Law Journal, which has a paywall. Rule 1.12 doesn't require media notice. White didn't change her name. She hired a judge. White thinks she gets to decide what days she represents Ira and what days she doesn't. Everything works for the cabal's benefit in the Irrational World. White claims the case was not open since we had no motion practice, as if motion practice defines a case. However, appointee was still billing away, and he's claiming judicial immunity. They don't get to have it both ways. Either the case is open or it's closed. The problem was, receiver wanted me to remain silent as a woman when he incorrectly listed the house with critical errors like the number of floors, rooms, bathrooms, square footage, and even the town. He didn't even know where it was. Receiver thought he could sell a home with water pouring through the brownstone ceiling, no heat, no hot water. This is the Irrational World. Even Judge Katz was in White's office, and Judge Katz failed to disclose. It was so significant the Brooklyn media covered it. And yet, when the issue was about whether the office was too teeny for screening, this was a critical issue. It is just incredible that only in an irrational world a Supreme Court judge
Ms.
could
Schechter,
overturn an appellate court decision.
your time has expired. You have an opportunity to respond after the respondents have been heard. Thank you.
Thank you.
Hello? I can't see that table, so. Go ahead, please.
Thank you, Your Honor. Good afternoon. May it please the court. My name is Judith White, and I am a member of Leon of Chung, White, Kim, Ruger, and Richter, counsel for plaintiff respondent. I watched a number of arguments in preparation for today, and many start with why their case appears on first blush to be simple, and then they go on to tell you why it really isn't. I'm going to do something different. I'm going to tell you that it is simple and stick with it. The standard here is whether the lower court abused its discretion in granting the receiver's motion in its entirety to effectuate the sale of the Bridgehampton house without interference by the defendant appellant and with cooperation by both parties. or in denying the defendant appellant's cross motion in its entirety and refusing to allow her to make a mockery of the court, specifically denying her the opportunity to relitigate matters she has raised over and over again, some of which have already been denied by members of this very panel, others of which she acknowledged in the first appeal were not an issue, and denying her application to have me and my firm removed on the bogus allegation that we were in violation of Rule 1.12 of the Rules of Professional Conduct. All of defendants' claims arise out of one theory, as you just heard, that the prior judge, my firm, the receiver, the new lower court judge, Judge Katz, now the grievance committee, and this court are all in a massive conspiracy against her and in favor of plaintiff appellant. Defendant appellant has provided not a single stitch of evidence to support her position. In fact, all of the evidence is to the contrary. The decision after trial provided her with at least 50% of every single asset accumulated during the marriage, with the exception of the plaintiff respondent's law partnership, an asset that is regularly disproportionately distributed, but here one this very court determined defendant appellate interfered with and caused to significantly decrease in value. The court here then upheld a decision granting defendant appellant 40% of the value of that asset. The lower court took pains to individually divide each and every account. In addition, although defendant appellant received her law license during the marriage, in this 19-year marriage, where she was approximately 47 years old at the time of commencement, she was granted 12 years of maintenance. The only remaining asset left to be divided is the sale of the Bridgehampton house. And although this very court upheld the decision to appoint this receiver and the authorities he was granted, she comes before you and asks for a do-over. She claims that she's been deprived of the true value of the Bridgehampton home, which has been on the market since 2014 without a single offer anywhere near the range in which defendant appellant believes she is entitled. This is a recurring theme, as well as defendant appellant also complains that the appraisal that was before the court at the trial in 2012 was inappropriate, and yet not a shred of evidence was brought to the court at that point to say that the value should have been differently. But, Your Honors, if you go there, I submit she's already led you down the garden path of chaos that she creates at every appearance, in every attempt to file papers, and even the most simplest act of scheduling. You simply need to look at the record that defendant appellant has provided, her 4-volume tome of complaints, including orthodontia and bar mitzvahs for children who are long emancipated.
Would you please wrap it up?
I see I'm out of time.
Yes. The light's on.
Your Honors, it's a simple answer. The court was well within its discretion in both upholding the motion for the receiver and denying in full the cross motion by the defendant appellant. Thank you.
Thank you.
Good afternoon, Your Honors. My name is John Sheridan from Herrick Feinstein. I'm here on behalf of the receiver, Yariv Ben-Ari. In Ms. Lintz's argument, she quotes from Casablanca. In her brief, she quotes from W.C. Fields, Carl Sandburg, and the Bible even. Now, in response, I can only refer to one theatrical comment, and that's from an old television commercial from Wendy's. Where's the beef? There's absolutely nothing to do, no facts, to back up her opinions in this case. There is the only appraisal that was submitted was the appraisal that was received by the receiver. Ms. Lintz complains in her brief that, oh, I never had a chance to get an appraisal. She never asked for access to get an appraisal. She could have gone to Judge Katz and said, I need an adjournment to do an appraisal. That never happened. And the things that she's, as Ms. White noted, there's plenty of things in her brief that were already decided even by this court. In fact, Judge Oing, on one of the appeals in this case, that panel refused to upset the receivership, and in fact, that panel refused to even let the receivership powers be limited. There's nothing that in this 8,000 pages of record, most of which have absolutely nothing to do with this court. And interestingly, although Ms. Lynch is proceeding pro se, she's also an attorney, duly admitted to practice before this court. If I were to put some of the stuff in a record like this that has absolutely nothing to do with the case, I think the grievance committee would come looking for me. For example, she says no receiver was needed. That was one that was already decided by Judge Oing's panel. The receiver, Ms. White opined about all that. And the most telling is Judge Katz's decision itself. It seems to me that you need a receiver because this case has lasted for so many years, because apparently the parties to the action have been unable to come to an agreement whatsoever at any point during this case. The bottom line is my review that the order appointing the receiver shows, as well as at the appellate division case, Judge Oing's case, that the receiver has the discretion and authority to sell the house. There is nothing in the papers that shows me that the receiver has in any way abused that authority. The receiver has the authority to sell the house, and there's been no showing that he acted beyond his authority or that this isn't a bona fide deal. And the only appraisal that I saw was the one that shows that it's actually a good price. Judge Katz's order should be affirmed. Thank you.
Thank you. Ms. Schachter, you now have an opportunity to respond.
Thank you. They want to make it simple. Why? Because it hides the lies. They want less papers. Why? It hides the lies. For instance, the appellate court decided that it was the economics that changed it, not I ruined anyone's career. So one lie. We received an offer for Bridgehampton for $5.8 million. They want to forget about that. I couldn't get an appraisal because I was barred from the property. We didn't have a judge assigned, but those are inconvenient truths. People joke about the matrimonial mafia for far too long, like they did Hollywood's casting couch. The behavior and collusion are unacceptable, and it's time to restore justice to our court and to end the matrimonial mafia. It is unthinkable that any attorney can hire a judge and fail to disclose for 7 months. It is unthinkable that a receiver can list a house where the square footage is wrong, the floor is wrong, the number of rooms are wrong, the bathrooms are wrong, and think it doesn't impact the house. It is unthinkable a receiver took 4 years to sell a house to an ex-husband and billed $153,000. I didn't ask for the receiver. What's crazy is Ira did. Why? He needed the receiver to sell him the house below the market value. We had a bona fide offer, $5.8 million. Ira refused, which was $30,000 once the broker negotiated, below what the court had said was the minimum of 5.9. Ira hired White for $50,000 and spent hundreds and thousands, if not millions more, rather than pay me the $30,000 difference. I rely on facts and I document every single fact, which is why it's so thick. So I urge the court to terminate Judy White and her firm as counsel, require Ira to pay the mortgage maintenance post-fire since he caused the damage and caused wasteful disposition of the Bridgehampton, property, to terminate the receiver for breaching his fiduciary duty and obligation to me, and receiver's law firm should reimburse me for all their outrageous fees, and Irish should pay the receiver's bills since he demanded a receiver to benefit him at my cost. The appellate court should award me any and all damages for the damage done to my life for the last 15 plus years. The divorce tethered me the court system for 15 plus years, which is untenable. In June, I am moving to Boston to attend Harvard's Kennedy School, and I want my life back. This is simply an abuse of the court system. Thank you.
Thank you. Thank you all. People versus Lugo. Is submitted, I'm sorry. The next case is Alozio versus New York Presbyterian. Right? Was submitted yet.
He's waiting.
Okay, go ahead, please.
Good afternoon, Your Honors, and may it please the Court, Devin Masor from Reed Smith, appearing pro hoc vice on behalf of Defendant Appellant BSB. Your Honors, to exercise personal jurisdiction over a non-resident defendant, a plaintiff has the burden of proving that the defendant engaged in specific conduct targeting this state. Here, the undisputed record on appeal, including the affirmations by BSB's CEO, Dr. Kanabe, make clear that BSB is a small, nonprofit entity that conducts all of its activities exclusively within Germany. It has no contact with New York, it does not target any New York entity or individual, and it receives no payments from any entity outside of Germany. These facts do not meet any legal test for jurisdiction under either Section 302 or the Due Process Clause.
Counsel, can I interrupt you? Is there sufficient, or actually, let me ask you this question first. Was it raised below that there should be jurisdictional discovery? Was that raised in front of the motion court?
I believe that it was raised in possibly the response brief.
In the reply?
Not in our reply, no.
Okay, I'm sorry, of course. All right, moving on then, whether it was raised, let's assume it was raised. Has there been a sufficient start that would be enough to justify jurisdictional discovery?
The short answer, Your Honor, is no. Jurisdictional discovery requires more than speculation and conjecture, which is all the record shows the opposing parties have given in their briefing. The speculation relates primarily to the relationship between AKB and BSB, as well as the payments received by the BSB from another German entity, the ZRKD. And the record has all the information that this court needs to make the determination on personal jurisdiction. And the fact that the opposing parties may disagree with the affidavits that were submitted by Dr. Kanabe is not a basis under the standard for personal jurisdiction. If I may, Your Honor, turn briefly to the purposeful availment prong, which I think you'll all recognize underlies any question of personal jurisdiction before this court. The record is abundantly clear that there was no specific targeting by BSB of New York. There were no contracts with any New York entity, no solicitations, no physical presence in New York, no services provided, no sales made, communications rendered, or any agreements with any distributors. The conduct that's at issue here by BSB was purely responsive and occurred exclusively in Germany. And that included identifying the donor.
BSB has a relationship with AKB, right?
They do, Your Honor.
And does AKB have a relationship with the hospital here?
Not that I'm aware of, and I don't believe that's reflected in the record in any way. And the relationship that exists, Your Honor, between AKB and BSB is purely one of, it occurs purely within Germany. And so that underscores the fact that BSB has no further contacts with New York, including, I think it's critical fact that the courier that was selected here to bring the donation to New York was not under BSB's control. So it had no say in ultimately where that was headed. And the bottom line, Your Honors,
Well, somebody told that, I don't understand that. Somebody told the courier where to go, right?
certainly, but it was the actions of the plaintiff, Your Honor, that brought the donation into New York. And that is not the standard for exercising personal jurisdiction over a foreign entity.
The actions of the plaintiff or the actions of the hospital?
The treating physicians who ultimately made the request to the National Donor Database in Minneapolis, which then in turn conducted the search that turned up the hit in Germany through not only Germany's national database, but also the entities AKB and BSB.
The entire EU gets searched, doesn't it?
I'm sorry?
Doesn't the entire European Union get searched?
I know that the search is generally broader when it's conducted by the national database in the United States. I'm not sure what was searched here. If I may, Your Honors, turn briefly to the substantial revenue prong, which is another independent basis for finding that personal jurisdiction does not exist here. You'll see in the briefing, Your Honors, that essentially the opposing parties concede this fact as it relates to BSB. And Justice Moulton, going back to your question about the relationship between AKB and BSB, it seems the entire basis for that connection here is based on an inadmissible Google translation of a website that makes a statement that the opposing parties then try to impute to BSB by virtue of a parent-subsidiary relationship. And, Your Honors, there's
The website is quoted in New York Presbyterian Hospital's brief, isn't it? And they urge us to consider it. Why shouldn't we?
I'm sorry, say?
I'm sorry. The website is cited in New York Presbyterian Hospital's brief, and they urge us to consider it, even though the translation may be not qualified. Why shouldn't we consider it?
Well, ultimately, Your Honor, I don't think it matters, because even if we accept the speculation on the opposing party's part that there is a relationship and that AKB made these statements, Dr. Kanabe's affidavit makes abundantly clear that there are no contacts with New York by way of AKB that would be sufficient to give rise to personal jurisdiction. And that's before you even get to the question of whether a parent and subsidiary relationship is enough to give rise to personal jurisdiction over a subsidiary, and that's simply not the law here, Your Honor. Finally, if I may, on my third point, the fairness question, which I think underlies all of this, is one, and I'm sorry,
Just finish your thought, please.
Put simply, Your Honors, the question of whether a defendant's contacts with this state are sufficient to give rise to personal jurisdiction is independent of the question of the merits of the case. And that is why here we respectfully request that the court reverse the lower court and dismiss BSB from this action.
Thank you. Go ahead, please.
Good afternoon, Your Honors. May it please the court, Scott Horn, counsel representing the plaintiff respondent in this matter. It's our contention, Your Honors, that the motion court properly determined that the New York courts may exercise personal jurisdiction over the defendant, BSB. There is no question that BSB agreed to supply its product to an identified New York resident used in New York State and caused injury in New York State. The record shows that BSB knew exactly to whom its product was going and why. Moreover, since this was always intended to be a New York-directed transaction, BSB could have reasonably anticipated that its admittedly negligent act would have consequences in New York, and the analysis really is that simple. Likewise, the injustice of permitting BSB to evade responsibility for its admitted error, in an error which took the life of a New York resident, is patent.
This is Judge Owen. Can you hear me?
Yes, I can, Judge.
Okay, great. So let's peel it back a notch. In terms of the defendant, did they advertise or solicit business?
No, they didn't, Your Honor. This is not an advertising or a solicitation case. It's
Okay.
much different footing.
It's not the single act situation then.
Well, with reference to 302A1, it is the single act. So I think that there needs to be a distinction drawn between the two different parts of the statute. Under 302A1, New York is a single act statute, and 302A1 doesn't talk about soliciting business or transacting business. It talks about contracting anywhere in the world to supply a good or services in this state. And I respectfully submit, Your Honor, that that's exactly what happened here. They made an agreement, whether it's in Germany or anywhere else in the world, to supply this product to this individual in New York State.
Well, I'm not so sure. I mean, yeah, there's an agreement to supply the specimen, but I think they were reached out to because the registry here in the United States couldn't come up with a match, and then it found a registry over in Europe, right?
That's correct, Your Honor, but whether they reached out, marketed, targeted, that only speaks to A3. It doesn't speak to A1 with transaction.
Okay, so how about this then? A1 then, you still have to do the minimum contacts, right? I mean, you still have to have the due process. I mean, everything putting aside, you still have to reach that, we all learned in law school, that threshold, minimum contacts. How do you show, or how do you purport to show that the defendant, that there was minimum contacts with New York?
Again, it's very clear and it's direct. So once we establish that 302A1 has been satisfied, because an agreement was reached anywhere in the world to provide a good or service here in this state, the due process analysis is very straightforward, Your Honor. What the due process analysis is concerned with...
I got to tell you, there are a lot of law books that beg to differ, but okay.
Well,
you wouldn't be standing here right now if that was that easy and straightforward.
I agree that International Shoe is not one of my favorite law school classes, but...
It was intriguing. Let's put it at that.
In this instance, however, under these facts, the point is that the relationship between BSB, the state of New York, and the plaintiff's claim is direct and incontrovertible. And under the case law, the Williams case in particular, decided by the New York State Court of Appeals, this is where the focus needs to be, a direct relationship between the defendant being hailed into court here, the state of New York, and the claim. And across the board, the evidence here is they knew to whom it was going. It was going to a person in New York, it caused injury in New York, and it was used precisely the way it was intended to be used, and it's their admitted negligence that took the life of a New York resident.
But counsel, isn't the relationship attenuated? Oh, I'm sorry.
Okay, go ahead.
I mean, you have the doctors in New York, the doctors of the plaintiff reaching out to the U.S. National Marrow Donor Program, reaching out to all foreign donor programs, including the Central Registry of the Republic of Germany, which is the ZKRD acronym, reaching out then to AKB, reaching then out to BSB. How is there a direct relationship?
Well, again, Your Honor, the direct relationship is contracts anywhere to supply a good here in New York. That's what happened. Regardless of how it happened, what the supply chain was, what the chain of requisition was, at some point, BSB agreed to provide this good to a person in New York. And as a consequence of that
And that's
conscious
the
decision...
substantial relationship with the state of New York.
I'm sorry, Your Honor, say that again?
That's the substantial relationship with the state of New York.
That
in
is
your
the...
eyes? You
yes,
think,
under...
you think you satisfy the crude, how do you say this, Cruder?
Cruder.
Thank you.
Yes. Yes, so
Standard?
I'm glad you brought that up, Your Honor. So with regard to Cruder, Cruder indicates that, and clearly holds, that New York is a single act statute. The CPLR is a single act statute. In their brief, in their reply brief, the appellant tries to undercut Cruder by saying, well, it's outdated. It was decided in 1988. Cruder is a very pivotal part, an important part of the law in this state. So it's been cited 827 times, 11 times this year alone. It is a vibrant part of the common law in this state. And under Cruder, it clearly holds that New York is a single act statute. That single act occurred here when they decided that they were going to provide a stem cell product to a New York resident.
Thank you.
Consciously and directly. Thank you, Your Honor.
May it please the court, my name is Dan Ratner. I represent New York Presbyterian Hospital on this appeal. There is a document in the New York Hospital medical record from BSB entitled Repetition Donor Final Clearance, in which BSB identified the recipient of the donor stem cell as Ms. Aloisio, a patient in the United States. It clearly understood.
Counsel, I'm sorry, it's hard to understand you through the
Sorry
mask.
about that, Your Honor. Is this better? So the document specifically shows that BSB clearly understood that its product was going to be transplanted into a patient at New York Presbyterian Hospital. That's at page 187 and 188 of the record. So therefore, it's clear that BSB knew that its act could have consequences for a patient here in New York, and that triggers the long-arm statute. The other issue is the issue of revenue, substantial revenue. BSB received 30,000 euros in exchange for this transaction. That in and of itself, in our view, constitutes the derivation of substantial revenue.
Does it matter that that revenue came from the German government?
Well, it came, but it was its act of supplying the donor cell. They were repaid for that. So yes, there is a little bit of a chain of payment in here, not directly from New York Hospital, but it did derive revenue in international commerce for doing this, even if it came from a German.
So the source does not matter, is your position?
Well, the statute reads that it has to derive substantial revenue from interstate or international commerce. It's clear that the product went to New York. I would have to say, Judge, you also mentioned, however, that at the very least there should be discovery on this issue. We need to know more if the court is not satisfied regarding BSB's relationship with AKB.
Counsel, this is Judge Oing. I got a question, and this goes back to A1, 302A1, the single act, single transaction. Do you know, I mean, the BSB, they're providing this unique, this incredible product, the stem cells. Do you know, or is there anywhere in the record to know that how often BSB availed itself to New York hospitals?
That's not in the record.
But that would be the most obvious way to show if this company is constantly coming back to New York, because that goes to what my colleague Justice Gonzalez was saying. I mean, what do you have in terms of showing that this is not a single one-time event that occurred, that they routinely and every time come through here? Because single transaction, that's fine, but that has to be a purposeful single transaction. Like they knew this is going to be an ongoing activity, this is going to happen all the time. Did you do any of that? I mean, did you provide any of that to the court below?
There's no specific evidence about how often
right, so that
blood products found its way to stem cell patients in New York.
Yeah, so that would respond to, I think, Justice Molden's point about jurisdictional discovery. I mean, you got to give something, then you got to show at least something like that. I unless I overlooked it, I didn't see any of that in the record.
Well, I think that we made what I think the legal standard is whether we made a substantial start in raising this issue.
But,
and we certainly,
that argument was raised during oral argument in terms of jurisdictional discovery. That was sort of a throw. It was like a Hail Mary pass that I saw when I read it in the record that came out of nowhere.
well, I think that the issue is an abuse of discretion standard, and I think it wasn't an abuse of discretion to rule in our favor, but it wouldn't be an abuse of discretion to remand this case back to the court for to flesh out the record a little bit more. We certainly did show a lot by introducing the website, by introducing the medical records, by understanding the nature of this single transaction. We did do a lot.
But the website's in German, unless I'm mistaken. It's in German, right? It's not in English.
Yeah, I would just like to point out that opposing counsel below and in this court did not actually contest the accuracy of that translation. Yes, he's raised
Yeah, that's fine. I'm not getting into translation. I'm just saying that it's in German. It's not even directed at a United States or to the US audience. It's in German.
Right, but it specifically mentions how BSB transfers stem cells throughout the world, so.
Yeah, if you read German.
Thank you.
I
Thank you, Your
don't.
Honor.
Thank
Thank you,
you.
Your Honor.
Counsel, I actually have a question. I'd like to go back to your opposing counsel's argument that the Crowder case really is applicable because you have the single act that was purposeful and it was part of a substantial relationship. Can you address that?
Absolutely, Your Honor. And I think the bottom line here, as we indicated in our reply brief, is that the single act, if there can be one single act here, that occurred in Germany when BSB handed off the donation to the courier that it did not arrange and that it did not coordinate with. And so that in and of itself, Your Honor, shows that the actions here were not directed to New York. They were solely of a local nature. And under New York law, that simply is not enough to draw a foreign defendant into the courts of the state. A couple other points, Your Honors. You heard from my colleague that there was foreseeability here and that the BSB should have known that this donation was going into New York. And with all due respect, that simply doesn't matter under New York law. We cite a number of cases, including the Etra versus Mata case and the Ingram versus Carroll case, in which the defendants knew that their patients were New York residents, and ultimately that did not give rise to personal jurisdiction. And so as a result, under established New York law, there is no foreseeability test that would allow foreseeability standing alone to give rise to personal jurisdiction. And that's underscored in Section 302A3, which not only has a foreseeability requirement, but also requires that there be substantial revenue from interstate commerce. And on that point, the last thing I would add is that Dr. Kanabe, in his affirmations, indicated that payment was made by the ZRKD to BSB, regardless of whether there was payment from any third party received.
Thank you. Thank you all.
Thank you.
Next, we have Ferguson versus Durst Pyramid. Go ahead, please.
Good afternoon, Your Honors. May it please the Court. Adrian Yaron of Cullen and Dykeman for defendants' appellants. At the heart of this matter is the conflicting affidavits of plaintiff's witness Carl Fumia and defendant's witness Ken Freshnock. Between the two of them, they cannot agree whether or not there was a safe alternative access.
Counsel, weren't you aware that Mr. Fumia was a potential witness in 2015?
Indeed, Your Honor, there were probably hundreds of construction workers on this job site. We had already 4 different testimonies by different EBT witnesses, including plaintiff himself, that testified that there were alternative access points to this crane pad. The scope of discovery is broad, but also reasonable. Would it be reasonable to require every defendant in every construction law case to literally depose every single construction worker who happened to be on the job site that day? We had 3 witnesses testify that the northeast ground level access point was available. Plaintiff himself testified that he had previously gotten onto the crane pad on the east side.
Okay, Counsel, that ship has sailed, though. There's been a finding of liability here, correct?
Indeed, Your Honor, but that was following the dismissal, original dismissal by the motion court, which found, first of all, that Fumia's affidavit shouldn't have been considered because it was submitted for the first time in reply, and because Fumia didn't establish that you couldn't get on the crane pad from the northeast corner. This court then found that the testimony of the witnesses that said there was available places didn't refute that affidavit. So this court reversed. Subsequently, there was discovery had, which we found serious credibility issues as to Mr. Fumia's affidavit and as to his.
Well, counsel, one of the things you cite is that Mr. Fumia may have misstated when he became a supervisor on the site, correct? Why does that matter?
That's fully established by his payroll records and the affidavit of his
But why does
employer.
it matter, though? Why is it material if he made a mistake about that?
It begs the question, Your Honor, is he correctly remembering the date and just misremembering his title? Or is he thinking of another date when he was the foreman sometime after the accident? And again, we have the affidavit of Freshnock that was brought out, who said, wait, I examined this crane pad just before and just after the accident, and on both times I found the northeast corner ground level access was accessible. These two affidavits are in conflict. It's a classic question of fact.
But counsel, I just, maybe you can explain. There was no rebuttal to Fumia's affidavit, am I right?
Yes, it was submitted in reply.
Pardon?
It was submitted on reply to the plaintiff's summary judgment motion.
But you had an opportunity with respect to your cross motion in your reply to respond to Fumia, right?
Well, not me personally. It was many years ago.
Not you.
But, I mean, at that time, that discovery, I mean, that investigation hadn't had an opportunity to be done because we were surprised after the note of issue and after the motions were brought with this affidavit that conflicted 4 other witnesses' testimonies, including the plaintiff himself. In the interest of justice, do allow this court to look at the facts and say, hey, the public policy of this state strongly favors deciding things on their merits. There is a question of fact here that should be submitted to the jury. Just briefly on the other issues, if this court does remand for trial, then the EBT of Mr. Fumia is clearly warranted as he has material and necessary information. As to the discovery on damages, the original discovery motion was denied as moot because summary judgment was granted to defendants. So the note of issue really should be stricken and discovery on damages be allowed. With respect to the specifics, I refer to my briefing.
Thank you.
Thank you, Your Honors.
May it please the court, my name is Scott Singer, and I represent the plaintiff respondent in this matter. A couple of things I want to clarify about this question that I believe Justice Gonzalez posed about right to reply. So after we served our reply papers, which included the Fumia affidavit, there was a 3-week interval they were allowed to respond as they saw fit. They didn't. They referred to the Fumia affidavit. They were aware of it. They made some general comments, but they didn't in any way contradict the essence of what Mr. Fumia had said. The second point I would like, well, alternatively, if they felt there was a possibility that there was discovery that might change the result, then they should have invoked 3212F, which allows the court to say, if it may be down the road we can find evidence, the court could have considered that. They did not invoke section 3212F. This was done. They had their opportunity. They did not avail themselves of the opportunity to contradict Mr. Fumia in every way. And frankly, I want to clarify this a bit about the access from the Northeast. Plaintiff was attempting to access from the south side of the pad. He would have had to negotiate a way along the periphery of the building and then up to the northeast corner, quite a long distance. I believe I calculated in my brief. Then he would have had to get from the northeast corner to the place where he was working, whereas he could have just he did what everybody else was doing on the job, which was to step up on the bucket and reach where he had to reach. If you look at the photographs, and there were very good photographs taken, They were taken, they were offered by the defendants. They were taken 2 weeks after the accident, but they showed the conditions there. It would have been virtually impossible for a plaintiff to have walked around the periphery of the pad in the way Mr. Freshnock suggested.
Counsel, speaking of photographs and social media, why shouldn't you have to provide this discovery concern from his social media accounts? Because it's relevant to damages.
Justice Moulton, this was a publicly available social media account. They took all the pictures. They had a chance to look at all the pictures. There's been no showing that there were any pictures that were not available to them or were not shown. And all the pictures are, frankly, show a nice family, doing their,
So you don't have any problems with the defendant's access to the plaintiff's social media?
Well, they've already had it. It was an open account. They looked at it. They saw it. They found the pictures.
So the answer is we have no problems?
Well, I don't see they're entitled to it because they haven't made the preliminary showing that they're required to make under the case law that there's something there. There was no there, and there's no potential for there being there. So I don't see anything. And the rest of their requests, we responded over and over and over again. IRS, Social Security, we provided. And in fact, in my brief, I note that there were 4 different funds from Local 580. They said, oh, we couldn't find what we were looking for. We gave them all the funds, all 4 of them. And it's documented in the record.
But didn't your own expert rely on some information from the funds?
Yes, and we provided the access to the fund
You
records.
gave all that information to the defendant?
Yeah, there were 4 different, there's a pension fund, annuity fund. We gave them all of it. They had all of that, all the authorizations were given.
No, but your expert used records from the funds. Did you provide the records that your expert relied on to the defendant?
No, I think we just provided, I'm not sure, but I know that we provided authorization for those records, all of the fund records. So that being said, I would ask that the court affirm and treat this as it, I think, ought to be treated as essentially a frivolous application. Thank you, Your Honors.
Thank you.
Thank you, Your Honor. As you can see, plaintiff doesn't actually dispute that there are conflicting affidavits with questions of fact. He urges this court to elevate form over substance. Every court in this state has said that shouldn't be done, that the public's policy says, look at cases on the merits, and that if there is a conflict of fact, a question of fact, it should be referred to the jury to decide. And I urge this court to do so. Sorry, Justice Soin?
No, I'm fine.
Okay.
Thank you.
I thank, by the way, plaintiff's counsel for raising the questions of the photographs. This story about acrobatics and jumping over things is of whole cloth. There is no testimony of it whatsoever. It's a figment of plaintiff's imagination. He's basically pointing out that there's further questions of fact here as to the interpretations of these photographs. Go ahead, Your Honors, look at these photographs. When I look at them, I see a clear pathway all along the the south side of this, all the way to the east end.
We have the record, counsel.
I see pathways going to the north side. I see a whole open space going to the north side next to the crane. That's my interpretation. Is it this court's job to interpret photographs, or is that the job of the jury? It's another question of fact in this case. In this case, yes, the procedural history is tortured and twisted, but this court shouldn't elevate form over substance. It should send this case to the fact finder to decide all these questions of fact. With regard to social media, we all know if a person marks a picture as private, that no one can access that except that person and whoever they let into it. So at the very least, there should be an in-camera inspection and a forensic analysis of what's on the social media for the lower court to determine if there's anything we're entitled to. With regard to the records, plaintiff keeps saying, oh, we gave authorizations. They never gave us the records. They never gave us the records that their experts relied on. They gave us authorizations which never resulted in these records. Many of those authorizations were time limited, and they went to government organizations that only accept them for limited periods of time.
Thank you very much.
Thank you, Your Honors.
Thank you both. People versus Bulina.
Good afternoon, Your Honors. Catherine Pecor with the Center for Appellate Litigation on behalf of Appellant Gabriel Bulina. Your Honors, the fact that juveniles and adolescents pose an exceedingly low risk of sexual reoffense is conclusively established by 3 decades worth of scientific research and cannot credibly be disputed. Nevertheless, the Sora court in this case concluded that it was absolutely forbidden from even considering this entire body of scientific research, even though it was highly relevant to Gabriel's claim and request for a downward departure and was not adequately accounted for the risk assessment by the risk assessment instrument. The Sora court's ruling essentially rested on a mischaracterization of defense counsel's argument. Defense counsel was not asking the court to invalidate the RAI or to say
Right, you're not contesting the points, you're just seeking a downward departure.
Exactly, and counsel, I think, explained that a few times, but the court persisted in misconstruing her argument and ultimately held, what the court said is that it believed it was prohibited from, quote, going into the underlying studies to make its own determination as to whether youth is or is not an adequate predictor of likelihood of reoffense. And I think that's the source of the error there. That is both legal error and an abuse of discretion.
Is it necessary, though, for the defendant to make a showing of specific causation as opposed to general causation? In other words, you have this data out there that shows what you say it shows, but does it have to be applied in a more individualistic way to the defendant that's in front of the SORA body?
Well, 2 responses to that. First of all, I would say no, because the risk assessment instrument itself has a number of factors that, are based on research and judgments that the framers made about population level characteristics of registrants. So I would argue that's not required, but in this case, Gabriel actually did present a convincing case for why this research applied to him and why in his specific case, this offense exemplified exactly the kind of youthful immaturity and impulsivity.
Counsel, I don't see this as youthful and impulsive behavior. I'm surprised, given the details of the sexual offense, I'm surprised that you would characterize it that way. It's one thing to say a kid goes to a store and grabs an item and runs out of it, and maybe under those circumstances you might say that's a childish, impulsive act, but someone who, I'm not going to get into the details because they're pretty disgusting, all right? I don't see how you call that childish.
Well, so 2 things, Your Honor. First of all, the research does not differentiate between serious and violent offenses and other type of offenses in terms of the risk of recidivism. But I think what, and of course this offense was serious and the conduct was reprehensible, and we're not disputing that. I think it's important to look at the context.
So why are you using the term childish when a person grabs a woman, puts her in a headlock, and proceeds from there, and then follows her? Come on.
So for 2 reasons here, Judge. First, I think it's important to look at the context of his life at the time. This is someone who's still in high school. He has cognitive delays. He is emotionally, he's acting out in school and getting in trouble all the time for sort of childish antics. The offense, it is, conceitedly serious. But that night, let's look at what happened that night. He stays out all night. He gets drunk with a friend. They shoplift from a store. And then he goes and takes drugs that were offered to him by a stranger in the park. This is a set of choices which are not, these are foolish choices, and these are not things that anyone should do. But I do not believe in any sense that this was premeditated or the kind of thing that is indicative of a permanent propensity toward violence. And that's really what we're looking at with the risk assessment instrument.
Counsel, I would like to move on to another point. So how do you address the fact that he was removed from the sex offender counseling and treatment program and then refused to re-enter that program? Can you address that?
Certainly. So First of all, factor 12, I think, is what you're referring to, Justice Kennedy, which regards acceptance of responsibility and willingness to enter treatment. So Gabriel did 4 months of treatment in prison. He learned a lot from it, as evidenced by his letter to the SORA court. He was removed for unrelated disciplinary reasons. And then what ultimately happened was he was in solitary confinement for a while. When he did have another opportunity to complete the program, at that time he refused to reenter it. I think, he had just come out of 2 months of solitary. He had lost his good time credits, and he was worried about being targeted as a sex offender in the general population.
And wasn't he also removed after less than a month in the alcohol and substance abuse program because he refused to participate?
Yes,
So you're talking about he had substance abuse issues, and this is why he engaged in this childish act, but he refused to participate in the programs that would treat the sources that you are referencing.
Yes, Judge, and I would just like to add, when he did reenter the community prior to the SORA hearing, he was back in treatment, and this is something that it's not as if he did not believe he would ultimately benefit from, for example, sex offender treatment and drug treatment. I think he had a lot of reasons for declining to participate at the time. I see my time is up. If I would just like to add, I believe the record is sufficiently complete for this court to grant the downward departure as requested through the use of its own discretion. But at minimum, Gabriel is entitled to remand to correct the abuse of discretion made by the lower court.
Thank you.
Good afternoon, may it please the court. My name is Megan McLaughlin for the people. The SORA court here acted well within its discretion in adjudicating this defendant a level 2 sexually violent offender. The defendant scored the maximum amount of points before entering the level 3 threshold based on the fact that he sexually assaulted a woman he had stalked for several blocks before following her into an apartment building, getting into the elevator with her, all because, by his own admission, he wanted to have sex with her. The violent nature of his attack, the fact that he attacked a stranger, and the fact that he forcibly pulled her clothes off to expose her breasts during the assault all emphasized the dangerousness that this defendant posed. Defendant's own attributes, including his criminal history, that he struggled with drug and alcohol abuse, that he refused refused treatment and was expelled from sex offender treatment and was only 18 when he attacked the victim, only served to increase his risk of reoffending.
And counsel, would you say that the offender's age also is, as it corresponds to the risk of reoffense, is already accounted for?
Absolutely, Your Honor. The RII squarely and directly addresses and accounts for the age of the offender, specifically being under the age of 20. So to say that the RII does not adequately account for that is completely incorrect. Defendant's true contention with this factor is that he believes that it's incorrectly accounted for, which is not the basis for a downward departure. The Court of Appeals laid out exactly how a downward departure should be given, and it is not based on defendant's disagreement with whether or not a certain attribute mitigates or increases risk. It's about something that the RII didn't take into account. And that's not what this defendant is claiming. If there are no further questions, I rely on my brief.
Thank you.
Thank you.
Tell them that Judge Owen is flashing on.
Your Honors, the risk assessment instrument cannot have adequately taken into account this vast body of mitigation research related to juveniles and young adults because that research did not exist at the time the risk assessment instrument.
Well, counsel, he's not a juvenile. He was 18 years old. That's not a juvenile. He was 18.
It is not a juvenile under the law, but Your Honors, as we explained, and I won't go into detail, but I've cited quite a bit of research in my brief that explains that even at the time of the SORA hearing, but increasingly now, scientists are understanding that these principles apply equally to individuals up to age 25 or 26. And the reason for that is because Gabriel, at age 18, his prefrontal cortex is still developing. He simply does not have the same ability to resist impulses and understand long-term consequences as an older adult.
So it was an impulse to follow a stranger into an apartment, put her in a headlock, and we know what else happened. That was impulse? Because that,
Well, I would just like to reiterate that that the research shows that even serious, heinous, and violent offenses, which I think we can agree that it was those things, even those types of offenses do not indicate the type of permanent dangerousness that the risk assessment instrument is thinking of when it adds points for Gabriel under Factor 8. But again, we're not asking, counsel was not asking the lower court, and I'm not asking this court to say that Factor 8 is wrong or that Factor 8 points should not be assessed. This is not a new legal rule. What we're asking for is this court to reiterate a foundational principle of SORA, which is that when the risk assessment instrument does not accurately measure someone's risk, the mechanism that the court has to use is to downwardly depart. That's exactly what a downward departure is for. It would make no sense if this corrective mechanism were only available where, for example, a factor takes something into account correctly, but not quite to its full extent, but to not have that corrective mechanism available where a factor gets it completely wrong in the other direction. That would mean that courts have the least discretion to depart in cases where the risk assessment instrument gets it most wrong. And I just don't think that is what the precedent, especially the Gelati and Johnson line of cases, intended to mean. Thank you.
Thank you both. People versus David Torres.
Good afternoon, Your Honors. Richard Wilstatter for David Torres. When the people deliberately select an adjourned date with insufficient dates for trial, while saying they wouldn't be ready for more than 2 weeks thereafter, the district attorney is effectively asking for the whole period of delay. That's what happened on June 18 of 2019.
Counsel, does it matter that they could have done the suppression hearing in the period allowed between whatever it was, July 2nd and July 8th? Does that matter?
It doesn't help them because the Court of Appeals has told us that being ready for a hearing is not enough to be ready for a trial. In other words, it's if you say you're ready for a hearing, which they didn't say, they made a misrepresentation of fact that they could be ready on July 2, the Tuesday before a Thursday Independence Day holiday. It's only on appeal that they're now saying, well, maybe we could have done the hearing then, but that's not ready for trial. The trial actually took closer to 2 weeks, about 7 trial days. The assistant didn't select the Monday, July 1st. They wanted Tuesday, July 2nd, so that there would be 0 chance the case could be tried during that period of time. And then they announced there were 2 weeks.
First question. This argument is preserved?
Yes, it is. It is preserved because defense counsel challenged the people's claimed exclusions as required by People versus Allard.
Did you argue that the plaintiff's statement was illusory because the case could not be tried in 3 business days?
He argued that it was illusory, and he argued that he didn't consent. He challenged the specific date, the June 18 adjournment. He's not required to make every argument. He didn't have the minutes. The court didn't have the minutes. There was a dispute of fact. The court was required to resolve the dispute of fact by holding a hearing, that is, by getting the minutes and deciding what really happened. That's what Judge Statzinger decided not to do. He just adopted the people's application to deny it whole hog without any analysis whatsoever and without seeing what was actually said. He relied on 2 representations that the people made in their answering affidavit by Ms. Wimmer. One, They said the defendant consented to the adjournment, which is false. We have the transcript. And two, they said that they could be ready for trial, that they could have been ready for trial, and they made a good faith request for that date, which we now know is false. They have conceded that they couldn't have been ready for trial during those 3 days. And so by announcing that the next 2 weeks were bad dates, which was obviously the gentleman's vacation, they were really requesting the entire period of time. The people's concession on appeal that they couldn't try the case, while obvious and not necessary, because of course we couldn't have tried this attempted murder case in 3 days, including the 5th of July, when the courts don't really like to work, and jurors don't like to work. But we certainly couldn't have done it within that 3-day period. By then immediately announcing that the next 2 weeks, including the Monday, the 23rd, I think, or the 22nd, the Monday, he was not available. And that's generally because people don't like to try a case on their first day back from vacation. But it's really obvious that this entire period of time was includable. And it was preserved by the defendant's reply, which was submitted to the court only 2 days after he got the people's answering papers, and after the judge summarily denied it. He argued that there was no consent and that the people's request for July 2 was illusory. And that's what People versus Allard said is necessary to preserve it. So for those reasons alone, the period of time, that the only 8 days left, is far exceeded, not even getting into what happened in January. And I just wanted to point out to you that the new statute says, notwithstanding any other provision of law, that's 240.50 sub 3, that it's written right into the statute that this is a preeminent need, a remedial statute that has to be given effect, that the people can't just say, oh, well, we don't have to do anything on January 1st, as long as the judge said January 8th. They were obligated. They knew they were obligated. And they could have sought a stipulation for a protective order, which is done in many, many courts. And they could have litigated their protective order in December. They're the ones who said 175 days were marked against them.
The statute didn't go into place until January 1st, correct?
Sorry, yes, that's correct.
Yeah. So why would they have to do anything in December?
Well, because they're doing it, their waiting is at their peril. They could have, if they really wanted a protective order, they could have litigated in December, just by saying, in January, we're going to have this obligation, so we want to limit the disclosure, even though Judge Obus ultimately found it could be released to counsel. They could have litigated that ahead of time or gotten a stipulation. But instead, they decided, as a matter of litigation strategy, to withhold the critical information from defense counsel in an attempt to do exactly what the legislature said shouldn't be permitted by enacting this new law, and that is by depriving defense counsel of sufficient time with this material before the trial begins.
Thank you.
Thank you.
Good afternoon, Your Honors. Dana Poole for the People. The People did not and do not concede that they somehow could not have been ready on July 2nd. There are any number of reasons that the People could have been ready on July 2nd, but not on July 8th. As we stated in the brief, they may have been ready to proceed to hearing. And that certainly would have, going to hearing would have stopped the speedy trial clock, and it would have served the interest of justice in moving the case along. They also might have determined that July 8th was a bad date to start a trial, but it may have been a perfectly acceptable date to be in the middle of a trial because of something that was happening later on. They might also have had a necessary witness who was not available for those 2 weeks that they said were bad dates, but might have been available before that time, and they might have been able to start the trial with that witness.
Is that in the record, counsel?
That is not in the
It's just
record.
hypothetical on your part.
Yes, and the reason that I'm discussing hypotheticals and counsel is speculating about the ADA's vacation schedule is because this was not actually preserved. Below, in the actual 3030 motion, defense counsel simply said he didn't recall the people answering ready during a period of time that included this adjournment. Then on his either what he intended to be a reply and turned into a re-argument motion, he simply complained, he claimed that the people's statement of possible readiness in the future is not a statement of present readiness, and present readiness is what is required. But the people were not claiming present readiness on June 18th. They were upfront that they were not available, that they were not ready on that date. They simply requested an adjourned date of July 2nd. And the law is very clear that when, as in a case like this, the people are in a post-readiness stance, having answered ready on many prior occasions, that they are chargeable only for the adjournment that they requested. So to the extent that any speculation is coming, that's a lack of preservation. And that's why counsel is asking this court to simply assume that the ADA was on vacation. And I am positing that there are many other reasons, and had counsel below tried to litigate that issue, we would have a fuller record for your court's review.
Counsel, was it proper to both submit the COC on January 8th and a motion? Don't they contradict each other?
Yes, Your Honor. And so what happened is the people got it out of order. It was a new law. They got it out of order.
It was a mistake then, in other words.
Yes, and Judge Obis found that the certificate of compliance was not valid and did not credit them for actually being ready to proceed to trial on the 8th. But because they had filed their motion for a protective order, and that does stop the speedy trial clock under both the old rules and the new rules, the people are claiming the exclusion based on motion practice, not on the people's claim of readiness, which Justice Obis ruled against us, and this isn't our appeal, so we can't argue to the contrary. So that entire period between the December adjournment date and ultimately going to trial on January 14th was properly excluded, as was everything but the 14 days that the people had requested in June of 2019. And unless your honors have any further questions, I would ask you to affirm the judgment of conviction. Thank you.
Your Honors, it's People versus Chavis, the 1998 case where the Court of Appeals held that a statement of readiness for hearing in no way demonstrates a present readiness for trial. So that's why I say, by asking for July 2nd, they were asking for a date that they could not be ready for trial. And with respect to the preservation issue, Judge Garcia's majority opinion, it might be unanimous, in People versus Allard, says that you can raise challenges to the people's claims exclusions in a reply or during a 3030 hearing. And the judge didn't hold a 3030 hearing, but he did raise, number one, that there wasn't a consent adjournment, and two, that the people's request was illusory. He didn't have those minutes, but we have them. We now know that the people's filed affidavit claiming they could have been ready for trial on July 2nd is not true. They made a not true representation to Judge Statzinger upon which he relied. And they further said that this adjournment was only to accommodate Mr. Weinstein, defense counsel, which is also not true. For these reasons, it's completely preserved, fully, as, you know, you don't have to have every single argument. You have to challenge the date. And he did. Not only did he challenge it by saying that their request was illusory, which means false, but he also said I didn't consent. That's the only thing that Allard requires. With respect to this motion practice, when the legislature enacts I'll be very quick. When the legislature enacts a new remedial law with language about notwithstanding what any other statute says, they mean that the people can't do an end around on this statute with gamesmanship in an attempt to prevent defense counsel from being ready for trial, just like they were doing in time immemorial that the legislature intended to stop. Thank you.
Thank you both. Highland Crusader versus Celtic Pharma.
Good afternoon, and may it please the court. My name is Craig Bono, and I represent Next Point Credit Strategies, the plaintiff and appellate in this matter. This case is complicated. It's complicated procedurally, it's complicated factually, it's complicated legally. I think the briefs do a pretty good job of addressing most of the issues, but I just want to raise two issues briefly with your honors, because I think that they had an overarching impact on the trial court's decision to ultimately grant the 4401 motion that defendants put forward midway through trial. The first issue is the no action clause. It's the first thing that the court decides in the transcript is that plaintiffs have no standing because the no action clause bars the claims because plaintiffs didn't go through the processes outlined in section 5.4 of the indenture. The problem is that the trial court didn't address section 5.9. Section 5.4, the first sentence says that the provisions of 5.9 are not impacted by 5.4. If you look to 5.9, what 5.9 says is that note holders have the right to bring a claim to recover payment of principal and interest if the notes go unpaid. That's what happened here.
Yeah, but who do they have recourse against?
They have recourse against whomever.
No,
Well,
against some of the
initially,
defendants. For some of the defendants, you have to show veil piercing, which I think...
Absolutely, Your Honor.
Right? And let's talk about that, because I think you've got serious problems there.
So, I guess to answer your initial question, the first recourse is against the entities that signed up to be on the hook, right? So
the guarantors or the IP companies, right?
Right, or
Okay,
the initial issuer.
What?
The initial issuer of the notes themselves.
Okay.
Right?
But there were no personal guarantees here. There were no negotiation to try to get a personal guarantee from any of these individual defendants, right?
That's correct, Your Honor. And had the process played out the way it was supposed to play out, where there was no shenanigans, there was no misappropriation of notes proceeds to pay management fees that weren't intended to be paid, that actually violated the indenture, and then we would not be sitting here today. That's not how it played out. And my point is that if you look to the trial court's decision, over and over again, he references the indenture trustee not being there, the plaintiffs not having standing, as he goes through the process of making his determinations on the evidentiary records. But the lens through which he is looking at all of that is incorrect because he got the legal issue wrong on the front end. The other legal issue he failed to address, or he was wrong on, was the limited recourse obligation. He called these notes a limited recourse obligation. But the notes aren't a limited recourse obligation vis-a-vis the note holders because Section 5.9, again, says that they have the right to bring these claims to recover principal and to recover interest if that goes unpaid, and that happened. And 5.9 says that's notwithstanding anything else, including the limited recourse provision. In addition, the notes themselves don't include a limited recourse provision, and under New York law, if there's a conflict between the indenture, which has a limited recourse provision, and notes which don't, the notes govern. So here, there are two reasons why the limited recourse provision don't apply. Again, throughout the decision, if you read, he continually refers back to the facts that these are limited recourse obligations. So all of the evidentiary decisions that he makes are made through this lens, which applies the incorrect legal standard on these two issues, which are critically important. So, in addition to the reasons why a plaintiff or the appellants request that this court reverse and remand the case in our briefing, if this court reverses and remands the case, allows the trial court to understand that neither the no action clause nor the limited recourse provisions impact the outcomes of the case because they're inapplicable under the terms of the documents, we will come to a different conclusion. We'll get to the end of trial. We'll be able to go through post-trial briefing. The court will make a determination on a full record with briefing rather than midstream where we are with no post-trial briefing, which is where this case currently sits.
Thank you.
Thank you, Your Honor.
May it please the court, Scott Edelman, Milbank, on behalf of the defendants. Your Honors, plaintiffs survived a motion to dismiss based on false allegations. They then took years of discovery, and then rather than proceeding through summary judgment, defendants let them go directly to a bench trial before Justice Cohen. Veil piercing is an extraordinary remedy. It has 3 elements, none of which plaintiffs established, as Justice Cohen made clear. 1, owners have to exercise complete domination of the corporation that is an abuse of the corporate form. They didn't establish it. 2, it has to be done in a way to commit a fraud or wrong against the plaintiff. Justice Cohen found they hadn't established it. And 3, there has to be causation resulting in plaintiff's injury. Except in extraordinary cases, one who enters into a contract with a corporation or LLC cannot pierce the corporate veil to recover as if they had a personal guarantee from the owners. Now, Justice Cohen patiently heard 4 days of evidence. He let plaintiffs offer whatever they wanted. He then heard argument over 2 days on a directed verdict motion. He asked plaintiffs how they wanted to argue it. They said they had a PowerPoint, and he gave them hours to argue their case. They never asked for additional briefing. They never complained that the procedure for argument was unfair. And then he found that they had failed to make a prima facie case. This was a bench trial, so Justice Cohen would have been the fact finder here, but he held that there was no need for defendants to consume an additional 4 days of trial time, which we had budgeted, with fact and expert testimony because no reasonable fact finder could find that plaintiffs had made a claim against either defendant at trial. The bottom line...
Counsel, what about the plaintiff's expert, Mr. Bethusium? Why wasn't his testimony enough to show at least some evidence of wrongdoing that would be a predicate for finding alter ego liability?
Your Honor, because Mr. Bethusium, when you parse what his testimony was, it didn't establish any wrongdoing. Mr. Bethusium admitted that the conduct did not violate the agreements that were in place. And what Justice Cohen found was that Mr. Bethusium's testimony boiled down to saying, well, I worked at GlaxoSmithKline, which is a big pharma company, and I didn't see behavior like this. But then he admitted, when he was asked, that the contracts that were in place before plaintiffs made their investment that governed the arrangements allowed for the behavior. He wasn't able to say that it violated the contracts that were in place. In addition, Mr. Bethusium he admitted that he was not able to say that any of the conduct that he was talking about had caused injury to the plaintiffs. And 2 things that plaintiffs don't address, and the no action clause, we're not even relying on that for the repayment. There's an issue there, but the principal issues here are, 1, they didn't establish abuse of the corporate form, they didn't establish causation, and they didn't establish wrongdoing. And they have to establish all 3. Any one of those failures is a basis for Justice Cohen's decision. And they didn't establish any 3. Now, in the case of the domination, the evidence was separate bank accounts, books and records, incorporated at different times for legitimate purposes, all of the same factors that were found sufficient in the Fantasia International decision, which Justice Mazzarelli was an author of, was on the panel of.
I may have been an author, I don't know.
May have been, but I don't know. But all of those factors were a basis for affirming a trial court's decision to overturn a jury verdict. So that was a case like ours where the trial court was faced with a jury verdict and it said, look, I've got all these things, transactions conducted at arm's length between the two companies, corporate formalities. And so too, here, Justice Cohen found that there were real boards of directors that acted as a check. He found that there were corporate formalities that were observed. He found that the entities acted in reliance on expert advice from well-known accounting firms and law firms, and so on and so on. And plaintiffs don't even address those issues in the reply brief. Causation, they argue that causation doesn't matter. It's not required. That's just wrong. The Fantasia case, which they call an outlier, it provides that it has to be a proximate cause of the injury. Fantasia has been cited for the same proposition by this department on numerous occasions. And in Bonderman, the causation requirement was also required. The SAS v. TMT case is another case that Justice Mazzarelli, you may have been an author of. We don't know.
I've been here so long, I could be.
That adopts the same
In any
standard.
event, your time is up.
Okay. Your Honors, the no action clause was an additional basis. Justice Cohen made that clear. There are multiple bases for the decision, and Justice Cohen's decision should be affirmed.
Thank you.
Yeah, I just want to briefly address the causation issue that counsel raised. Bonderman does not have a causation requirement. The alter ego is not a claim under New York law, it's a means of addressing liability. A claim, like the breach of contract, like a tort claim, you have to establish causation for the claim itself. But to establish liability, you have to establish domination and control and some harm as a cause to the individual that is seeking to recover, the plaintiff. That there is some harm is not the same thing as a proximate cause requirement that is required under the law. Bonderman doesn't say that. No court has said that since potentially this outlier case, which has not been repeated. There's no courts that are addressing it. No one is, I don't believe, except for maybe that case, there's been a plaintiff that has been dismissed, has had their alter ego claim dismissed as a result of a lacking proximate cause to establish the alter ego liability that they're attempting to establish. That level of burden just isn't there in the law, and that's not what we were required to establish at trial. What we established at trial was that the notes proceeds were used inappropriately. The corporate shell that was Celtic Farmer was used to do that, and thus the level of wrongdoing that's necessary to establish alter ego liability was presented to the trial court. Thank you.
Thank you both. 470 4th Avenue versus Adam America.
Good afternoon, Your Honor. May it please the court. My name is Joseph Giannini, and we represent the appellant Daniel Sebas. It's our contention, Your Honors, that the complaint was woefully inadequate in this case and failed to state a cause of action, especially given the heightened requirements of CPLR Section 3016 when it comes to fraud. There are no specific references made to Daniel Sebas except for one conversation that was held approximately a year before the purchase of this building. And those allegations are addressed or directed to 3 different individuals. Nowhere—
Counsel, wasn't that conversation particularly consequential, though, since there was no ability by the plaintiff to do invasive testing concerning the water damage
Well, that's contested, Your Honor.
Well, but it's a
First-
pleading motion, so that's enough, isn't it, for a pleading motion?
Well, the PSA did not prohibit any invasive testing. And that is admitted in the plaintiff's brief in a footnote on page 41. And when a material fact is alleged that really turns out not to be a fact, perhaps the lower court would not have given the favorable inferences to the complaint as it was bound to do. The documentary evidence in this case, the PSA, negates any favorable inference that the complaint is entitled to. And given that, when it comes to allegations of fraud, we say that you have to be more specific. You cannot just say that Daniel Sebas did this, that, and the other thing. If you're purchasing an $81 million building, it seems to me that you should be able to represent and plead who said what when, especially since you allege that that induced you to make this sale. My client was not a party to this contract. He did not negotiate the contract. They did not participate in any negotiations. They are not a party to it. There is no privity with respect to...
Wasn't your client the general contractor?
That's true, Your Honor, but...
Isn't it your client who's accused of cutting corners, using inferior materials, and a series of other improper acts?
That's an allegation.
Yeah, but this is, as Justice Moulton said, this is a motion to dismiss.
Yes. But the point is that there is no specific allegations in the complaint with respect to those claims. All right? There is no specific allegation that Daniel Sebas said this about that, or refused to disclose information, or did not state, the complaint does not state that the plaintiff relied on what they were saying, or that enticed them to make this sale. If a contractor builds a building, and then a year from now, someone who's going to buy that building asks the contractor, is the building okay? And his response is yes, and then it turns out that possibly there are problems with the building, that cannot create a privity here. You have no duty to disclose without privity.
Thank you.
I'm sorry, Judge?
I said thank you.
Oh, okay, thank you, Judge.
Good afternoon, Your Honors. Susan Mahan from Gardner & Bloom on behalf of the appellants, 470 4th Avenue Investors and Adam America LLC. Very briefly, Your Honors, I would like to focus on the two causes of action in the complaint. The first is the breach of contract cause of action, and the sixth cause of action, which alleges negligence.
I thought you didn't appeal from the denial of the motion to dismiss the contract cause of action. Maybe I'm mistaken.
No, what I am appealing, Your Honor, is the dismissal of, the failure to dismiss the sixth cause of action for negligence.
Okay.
The law in this state is pretty clear. Breach of contract and negligence claims can only be pled at the same time when there's some cataclysmic public interest involved. That's simply not the case here. What we have here is a plaintiff complaining about an alleged breach of the bargain. And those damages can be addressed in the breach of contract claim. With respect to Adam America LLC, it's pretty clear, it's obvious from the purchase and sale agreement. They were not a party to the purchase and sale agreement. They had no part in developing this particular property. They're not an owner of the property. They're not involved in the construction of the property. So including Adam America LLC was hope, a prayer, supposition by the plaintiff to, for whatever reason, but they don't belong in this case. Thank you.
Thank you.
Just gonna take a quick sip of water. Thank you. Good afternoon, Your Honors. May it please the court, my name is Erica Wolf. On behalf of the plaintiff respondent, 474th Avenue Fee Owner LLC, the buyer in this case. The buyer paid $81 million for a 12-story, 105-unit residential building in a hip Brooklyn neighborhood. The building was billed as luxury, all the bells and whistles, fancy finishes, balconies with nice views. Just months after closing on this property, they learned that behind these shiny fixtures, behind the freshly painted walls, there are a host of problems that would eventually lead the building to be dangerously uninhabitable and would cost them over $20 million to resolve.
Would you kindly respond to your adversary's statement that you, in effect, have conceded that an invasive inspection or inspections could have taken place?
Absolutely. I welcome the opportunity to respond to that because it's inaccurate. The complaint alleges, and as Your Honors have noted, on a motion to dismiss, it must be accepted as true, that the plaintiff was not permitted to conduct invasive investigations. The issue of that prohibition is relevant for a couple of reasons. I would say most notably in connection with the negligence claims, the negligent misrepresentation claims as to Danya Sebas, where they allege that we did not owe a duty at all, that they did not owe us a duty at all, excuse me. We allege they did owe a duty because there's a special facts doctrine, a well-established doctrine set forth by the Court of Appeals in the Kimmel case, that their duty of care and the duty to speak accurately.
Counsel, do you concede that your client could have performed invasive inspections to discover the defective conditions that were hidden from view?
No, and as alleged in the complaint, we couldn't. That prohibition comes, as we've discovered in discovery, which is not before the court at the moment because we're on a motion to dismiss, but that prohibition is explicitly set forth in the first option agreement, which governs the parties' rights and duties with respect to their relationship leading up to the purchase and sale agreement. It explicitly says in there that they could do only non-invasive examinations of the building. So with respect to that duty, and the relevance of whether or not we can conduct these investigations, Danya Sebas doesn't dispute that the special facts doctrine creates a duty. They just dispute that they had special facts. And the sole basis for them disputing that is this argument that they have that we could do invasive testing. We couldn't, and that allegation is expressly, that argument that they raise is expressly contradicted by our complaint, which has to be accepted on the motion to dismiss. Contrary to their arguments, the fact that the purchase and sale agreement doesn't contain the explicit language involving the prohibition does not constitute documentary evidence that we could do that. All they have pointed to is that there is this agreement, the last in a series of agreements between the buyer and the seller. The last one, the first one being the option agreement. The last one doesn't explicitly contain this provision. That is not proof that the buyer could have done invasive testing. That prohibition, I mean, it might just come from basic common law, right? You don't own the building, you don't have the right to go in and start poking down, holes in the walls, et cetera. There are 8 separate places in the complaint where we allege that we don't have the ability to do invasive testing. 2 of those, somewhat imprecisely, refer to that prohibition coming from the PSA. Most of them, 6 of the 8, don't. Those allegations have to be accepted.
You want to talk about the negligence causes of action while you still have some time?
Yes, so this does relate to the negligence clauses of action. I'll say briefly with respect to negligence as against the seller. The seller argues that those causes of action are duplicative of the breach of contract action.
We often hear that, so
Right.
why are they not?
Right, and of course, the Adam America and Danya Sebas say we can't bring negligence against them because we don't have a contract with them. But in this case, there is clear precedent. The negligence claim can coexist with a breach of contract claim because courts have consistently held that where there is a duty that is independent of the contract, it may persist along with the contract claim. And such a duty has been found explicitly in situations just like this, where there is a large multi-story, multi-residential building being built in an urban environment. This court found in the Trustees of Columbia University case that that public interest created a duty in negligence that allowed the owner of the building to maintain a claim for negligence alongside its breach of contract claim because of the defectively constructed building in a crowded urban neighborhood. In that case, there was facade falling. In our case, we have danger.
Isn't that reading of the Columbia case, that would mean that every single contract to develop a building in Manhattan would also give rise, if there was a breach, to negligence claims?
Not necessarily. We plead sufficient allegations in this complaint of a long-standing relationship between the buyer and Danya Sebas. For months leading up to the purchase of this building, we conducted numerous walkthroughs. We had our real estate examiner speak directly and explicitly ask questions of Danya Sebas. Danya Sebas worked very closely with the seller and with Adam America in marketing and promoting this building for our sale. So those facts coupled together with this public interest element, and I can't stress enough the public interest element here, because we had fire rating issues that were so bad that had our client not broken down the walls because of the water damage and seen what was behind there, there could have been a horrific fire that would have spread very quickly through this building.
Justice Mazzarelli, may I just pose one question? Thank you. I just want to follow up on that because I'm just not seeing the significant public interest or the risk of catastrophic harm, because really, you know, what's at stake here, right? We have faulty installation and operation of a certain system. We have gapping between the hardwood floors. So how is that, you know, relates to the Columbia University case and all the other cases where you really had catastrophic, you know, harm here? I don't see it.
Sure, and I think in trying to distinguish the facts of our case from the Columbia University case, Adam America really does mischaracterize the harm that we're alleging here. We are not talking merely about floors that don't look right, about PTAC units that weren't working properly. We're talking about the reason the floors don't look right is because there was pervasive water infiltration that filled this building, which led to significant mold growth. People can't live like that. People can't live with mold under their floor, mold in their walls. And we're not talking merely about, you know, sort of maintenance issues, like the superficial maintenance issues. We're talking about fire rating assemblies that, had they not been caught, could have led to a horrific fire. Unless there are further questions, I thank the court for its time.
Thank you.
Yes, Your Honor, just a couple of points. First, with respect to the special facts doctrine, it's important to remember that Danya Sebas was not involved in a business transaction with the plaintiff respondent. That is an element of that doctrine that is just missing here and should not be allowed, plaintiffs should not be allowed to rely on that. Secondly, we have to remember that this buyer hired an outside consultant, CBRE, to do extensive research and investigation prior to the purchase of this building. And despite the allegations to the contrary, if the court would just refer to page 41 of the respondent's brief, it clearly says...
Counsel, but we go back to the issue of whether the plaintiff was actually able to conduct invasive testing or whether it was forced to rely on Danya Sebas.
That's what I was just going to allude to, Your Honor.
Please.
Because in that footnote, they clearly say that the PSA does not contain language barring invasive testing.
But your adversary referenced the options agreement, did she not?
The option agreement is not part of this record, Judge. All right? And we're talking about it at the stage of pleading, what was presented to the court below. And what was presented was a PSA agreement where they admit that they were not barred from doing invasive testing. And I must point out, with respect to, part of this claim is the PTAC air conditioning units that leaked. All they had to do was turn it on. Turn it on, go back the next day. And if there's going to be a leak, you're going to see it. With respect to the windows, the way they test for window leaks, they take a hose and they spray water on the window. That's not invasive testing. All those things were available to them should they, if they wanted to avail themselves of it. And it's a long stretch to say that my client, who was not involved in any negotiations, defrauded these people. because they did not participate in the negotiations for the contract. I thank you, Judge.
Thank you. Thank you all. And now we reach Cepeda versus the City of New York.
Good afternoon, Your Honors. Harriet Wong on behalf of the defendants' appellants, City of New York and New York City Transit Authority. 18 years. The time it takes for a newborn infant to reach the age of legal adulthood, and also the exact
Counsel,
same.
your brief is eloquent about the amount of time it took, and it's clear. But wasn't there neglect on both sides?
Was there a different strategy taken by defendants when it came to pursuing discovery? Yes. I wouldn't necessarily call it neglect, nor would it be anything near what plaintiffs claim their first.
When you gave the BP, or the demand for a BP to the new counsel for plaintiff in 2011, did you say, and by the way, we've been waiting for this for 9 years or whatever it was at that time?
That was not written in our correspondence to the new plaintiff's attorney, but just from the dates on the answer and the demand served in 2001, it would be very clear to plaintiff's new counsel that when they were reserved in 2011, 10 years had already lapsed.
Counsel, is that a reasonable position in light of the fact that new counsel did not have let's call it a productive relationship with former counsel, and information was not forthcoming? I mean, it was to the point that the defendant was asked, the city was asked to forward a copy of the answer and demands because prior counsel supposedly couldn't find his files.
So, Your Honors, defendants weren't aware of that. So until the motion was made, defendants had no awareness that plaintiff's new counsel had any type of a conflicting relationship with his prior counsel. So it was not our duty to ask plaintiff's new counsel, were you able to get the file from plaintiff's prior counsel? And under the facts of this case, we don't even see why it would be necessary.
I guess what I'm asking you is whether the failure to alert new counsel to the fact that the BP and the discovery demands had never been responded to, whether the failure to alert new counsel was a tactic that backfired on the city. Because look at where we are now.
We are 2 decades out, but defendants didn't hide that information. I don't think there was ever a claim in plaintiff's papers that they were not aware that when they received the 2011 correspondence from defendants, that plaintiff's prior counsel did not respond. In fact, plaintiff's counsel in 2010, plaintiff's new counsel in 2010 when they were retained, apparently knew that there were issues with plaintiff's prior counsel because they were the ones involved in the disciplinary proceedings against plaintiff's prior counsel. They're the ones who actually state in their papers consistently, even on appeal, that plaintiff's prior counsel neglected plaintiff's case, did nothing on plaintiff's case, and was disbarred from practicing law because of the neglect in this case. And that doesn't explain the 9 years, or yes, 9 years from 2010 when plaintiff's new counsel was retained to when an attorney-verified bill of particulars was finally served.
Well, based on my experience in this court, I would say that if there's one party that understands what it is to delay cases and extend the length of cases, it would be the City of New York.
Well, unfortunately, this is actually a New York City Transit Authority case,
Well,
not the city.
The Transit Authority has also the same record.
Well, there's a difference between a minor delay and a 2 decades gap. And the 2 decades gap in this case from demand to a service of an attorney-verified bill of particulars.
Counsel, this is Judge Oring. I got a question.
Yes, Your Honor.
You're the Transit Authority.
the clock is ticking. Why didn't you move the failure to prosecute?
Yeah.
I mean, in this case here, we have a plaintiff. From the record, it seems like the lawyer really was the one that has the problem here. So, why didn't you move to failure to prosecute? I'm not understanding why did you wait? As like Justice Mullen says, there's delay on both sides. And the person that's getting the short end of the stick is the plaintiff.
Yes, it might be ultimately a decision against the plaintiff, even though it's the attorneys
Forget
involved, but
that was a gratuitous comment. I'm just saying, why didn't you move to dismiss for failure to prosecute?
it might have been a overload of cases because we have over 10,000 cases.
That's not a good answer. That's not a good answer. I was in private practice. We get overloaded too. Just got to move stuff around.
Yes, but Your Honors, that wouldn't have made a difference because if we had moved and served the 90-day, if we had moved under 3216 and served a 90-day notice, plaintiff would have filed a note of issue to prevent a dismissal of the case under 3216.
Okay, so then you go to try it. And so that would mean that if they filed a note of issue, discovery is complete, and you wouldn't be here 20 years later. The case would have been over 20 years ago.
That would also be an abusive process because there would be no discovery done on the case.
Well, then that's where you make your motion practice. That's where motion practice comes in, to keep the case going and keep it alive instead of letting it fall by the wayside.
And I guess
I'm just making the observation that, at this point, we have what we have in the record here, when this could have been handled a little bit better.
Thank you.
Thank you. I will respond in reply.
Right.
May it please the court, my name is Jay Breakstone. I represent the plaintiff, respondent, cross appellants.
You've got a lot of explaining to do, Mr. Breakstone.
I think both sides, as somebody said, and I couldn't really see from that corner, but some very wise jurist on the bench or on TV said, both sides have a lot of explaining to do. The situation here is rather absurd. And it's probably a product of engrafting upon a very ancient system in jurisprudence in this city, in this state, some new protections. And what I'm saying is that when I was first admitted, the concept was that it was up to the parties to move the case. You could easily sit and have a case that went on forever and never finished, so long as the court wasn't involved and nobody decided to involve the court, that would be fine. That has changed. And the way that it has changed to allow the defendant to hold the plaintiff's feet to the fire. And we have mechanisms to do that. We have mechanisms, we have 90-day notices.
Doesn't the plaintiff's counsel have an ethical obligation to move a case forward, counsel?
You're absolutely right, Your Honor. But those ethical obligations are not what's at issue.
So what happened between when you got the case in 2010, or was it 2010 or 2011?
I think it was 2010.
Okay, so why are we here in 2022? Why hasn't this case been put to bed by now?
Well, what happened, Your Honor, is that there was a almost unbelievable situation trying to deal with an attorney who was either disbarred at that point or not disbarred, had his leg amputated, who had no interest in whatsoever in cooperating in any way to put the materials together. And so it was necessary for the new attorney to come in and reconstruct this case.
Well, but one aspect of reconstruction is to find out who all the medical providers are, correct?
Excuse me, I missed that, Your Honor.
One aspect of reconstruction, and when you're coming in new to a case, you find out who the providers were for your client.
That's
Why
right,
did that
Your
take
Honor.
so long to
There
get
was some-
the authorizations to the transit authority?
There were some 19 providers. There was over 3,000, I think 3,500 pages of records. But the fact is, and Your Honor is not wrong, from an ethical standpoint, Your Honor is perhaps not wrong, but I wasn't there. But what I'm saying is that the transit authority sat for 18 years and did absolutely nothing to move this case. And now they come before the court and they say that the fault of that is solely on the plaintiff. And it's not, because the mechanism was there and never utilized by the Transit Authority. There was never a 90-day notice served. There was never even a letter served over 18 years that said, what are you guys doing? I mean, I know we're bollocksed up here
Counsel,
with
to
10,000 cases, but
twist what you're saying in a different way. So there's a statement that it took a long time to amass the documents and recreate the file and contact the providers and so on and so forth. But that period stretched out over many years as well. Was there any communication from the plaintiff to the defendant saying, hey, I'm doing this right now and I will get back to you?
there's none in the record, and I'm speaking now with the new counsel, not the old counsel, because
Yes.
obviously that's a different situation.
Yes.
But no, it's not in the record. But what I think is particularly interesting is when the bill of particulars is finally served, the response of the Transit Authority is, no, you're late. Not, why didn't you do this before? Not, what, we were very busy, we couldn't get in touch with you. Why not let's work together to work this out? No, lateness. And as your honors know, lateness is not a reason for dismissing a case. It's not. The dismissal for, and the Court of Appeals has said that, but the dismissal, the way cases are dismissed for being late, is when there has been a demand, and an appropriate demand, and those are legislatively created situations.
Well, there has to be a showing of willfulness, right? Under 3042D?
Correct, Your Honor, and that's what I mean by those are statutes, those are legislative statutories. You can't come up and say, you're late, thank you very much, and tap out. Can't be done. And under 3042, right, there's been no demand, there's been no motion to compel, nothing. Yes, you could say that plaintiff did nothing for 18 years, and there's reasons there. Prior attorney, 10 years, he had his problems. New attorney had to reconstruct his problems. And you can say maybe they're insufficient reasons. However, the other side of the coin is the Transit Authority has no reason for sitting 18 years and allowing this case to just sit. Maybe there was a tactical reason. I've never been a defendant. Maybe if you're a defendant, you say, no, if the plaintiff's not pushing the case, no skin off my back. I really don't care. I have 10,000 cases. I'll do the other 9,999 before I do this one. I don't know. But the obligation, before you come to court and say, dismiss this case because of delay, the obligation is you've got to be able to show, if you're a defendant, what you did to move the case forward.
Thank you.
What you did to hold the plaintiff's feet to the fire.
Thank you.
Your Honor.
So plaintiff's entire argument relies on 3216, which is not what the defendants moved on. Defendants moved based on 3042, and it's referenced back to 3126. And this court and the Court of Appeals in Gibbs versus St. Barnabas Hospital has said that CPLR 3042 and a plaintiff's failure to serve a bill of particulars is an appropriate means to dismiss a case. This court in Alomar held under even less severe circumstances where the bill of particulars was only delayed by 7 years.
Counsel, allow me to interrupt you. There was a different version of CPLR 3042 when Alomar was decided, right? The case that's current would be Hassan, and there you have to make a showing that the tardiness was willful, contumacious, based on bad faith. Hassan says that lateness alone is insufficient to warrant dismissal. Am I right?
Correct, Your Honor. And the plaintiff themselves concede that the first 10 years was willful conduct. It was willful neglect that warranted in the disbarment of plaintiff's first counsel. Then plaintiff's second counsel, for the 9 years that they had the case, they gave absolutely no explanation for that delay. They said it took several years.
Is that willfulness?
When you look at the prolonged extent of this case and the overall pattern of conduct, the significant delay could constitute as willfulness and bad faith. Now, even combine
So this is Judge Oring. Counsel, my problem is that you're trying to impute. I don't see anything in the record here where the plaintiff himself was the reason why this delay happened. It seems like you're trying to impute counsel's, whatever you want to call plaintiff's counsel, however you want to deal with it, all what happened there onto plaintiff. I'm not so sure that's proper. I mean, I don't see anything, unless I misread something or overlooked something. I didn't see the plaintiff being the person that's blameworthy here. Yet we're all trying to now impute, or at least transit authorities trying to impute all the transgressions that counsel committed onto the plaintiff. I'm not so sure that's troubling, I think.
I think, Your Honors, I've never seen a case where the court has separated the difference between counsel and the client. It's always been viewed collectively. This court, in a recent case of Carmody versus 208-210 East 31st Street Realty, specifically said the property manager who's involved in the case, the named defendant, said their counsel dropped the ball. Their first counsel dropped the ball, and this court still dismissed the case because it's not about what counsel did or what the client named defendant or named plaintiff did. It's collectively what the parties did. And if it's the counsel that conducted something wrong, there's a slew of case law concerning law office failure. And this court has never, when it comes to conclusory allegations, unsubstantiated law office failure, said, well, we're going to separate the law office failure from the client's rights because it's not fair to the client. Under those circumstances, the client can pursue their counsel for malpractice remedies, which is totally different than pursuing a defendant who has no involvement in the malpractice committed against the plaintiff client. So we can't just bypass plaintiff's counsels, both of them, for malpractice and then pursue the defendant just because 2 decades have passed in this case.
Thank you. Thank you all.
Thank you, Your Honors. Thank you. You too. Two attorneys, so you'll rarely see me anymore.